Detention Rehearing. What do you do if the judge decides to detain your child at the first hearing? The first hearing is a detention hearing. That's where the court decides whether there is a prima facie showing that your child should be removed from your custody, at least temporarily. Now, if you have a detention hearing and you lose and the court decides that they're not returning the child, you can have what's called a detention rehearing. Now, there are actually two types of detention rehearings. The first type is for a parent or guardian who was not present at the original detention hearing because they didn't receive actual notice. They can file what's called an affidavit with the clerk, and upon receipt of that affidavit, the court and the clerk must reschedule the detention hearing for an actual rehearing, and the hearing is conducted as if it were the original detention hearing in the case. So for all of those parents that didn't make it to the first hearing for whatever reason, file an affidavit to try to get a rehearing of the detention. The second type of detention rehearing is what's called a prima facie hearing. You as the parent have the right to present evidence and cross-examine the preparer of the detention report, which is the social worker. Now, this hearing is supposed to be held within 3 judicial days of the original detention hearing. Now, the court or one of the other attorneys may argue that you're not entitled to have a detention rehearing, but to set the case for trial within 10 court days of the original detention date. Now, you have to be careful, because if somebody argues that, you might be going to trial sooner than you think. At the detention rehearing, when it's based upon a prima facie showing, you and your attorney have the right to cross-examine the social worker and to present evidence to prove that there is not a prima facie case against you. And what do I mean about a prima facie case? A prima facie case is where the social worker can present evidence that meets the statutory requirements of bringing your case in front of the juvenile dependency court, and a prima facie case in stating and showing the court that there are reasons why the child should be detained from you and that there are no less restrictive alternatives. So before you ask for a detention rehearing, make sure that you can withstand a request to set the matter within 10 court days. And if you do have the detention rehearing, it's important for you and your attorney to strategize and talk about how the social worker will be cross-examined and what evidence you will bring to show the court that the child should not be detained from your custody. You know, I know you probably have questions, and I answer questions like this every day. If you have questions, please give me a call, 888-888-6582, and I'll be happy to help you in your CPS matter. Like this video and subscribe to our channel on YouTube.